Okay, so you see that these are some of the exceptions. One, agency, because you would have prof taught you law of agency. An agent is that person who acts on behalf of the principal, with the third party. So in agency relationship, the agent is one that deals with the third party, but then the action of the third party by the principal. But if this has to be, so the principal cannot say, you know what, you're not privy to, I'm not privy to the contract between the agent and the third party, so it's not binding. No. At the same time, the third party cannot claim that he has no relationship with the principal because he dealt with the agent. It's an exception. So even though the principal may not be a party to a contract between the agent and the third party, the principal can still enforce any right obligation that arise out of that contract. Insurance is the same thing. In a contract of insurance, let's look at motor vehicle, for instance. In a motor vehicle, where if you look at the motor vehicle insurance that you're having with you, it's just your name as owner and the insurance company. But then if you hit a third party, hit someone's car, that person will sue the insurance company and of course claim the compensation. The insurance company cannot say, you know what, it is not, you are not part of this contract. You can't say that because it is a third party policy. So even if the name of, you can't see the name of that third party into that policy, yet that third party can sue because it's an exception to it. The same thing with trust agreement. In trust agreement, the owner of the assets will hand over to the trustee to manage on behalf of the beneficiary. In most instances, the name of the beneficiary will not feature in the contract between the owner and the trustee. Yet the beneficiary can also sue on behalf, to take benefit of it. The same thing, contracts, bankers, commercial credit, the same thing, contract of charter parties, the same thing, covenants running with land, the same thing, statutory exception, the same thing. You know, like somebody that are buying land every day, you discover that, if you buy land from someone, you know, the first person that Lagos State government, for instance, would have given that property, they were covenants, covenant that the person would have entered into with Lagos State government. Now, if you buy that land, for instance, it could be the way of how, the kind of drainage that you have to put, the kind of spacing between your house and the road, the kind of environment that you need to keep, and all of those ones. Even sometimes the number of floors that you have to build and all of those things. Now, even if you buy that land from the owner subsequently, those covenants that owner had entered into previously before the land is sold to you still bind you. So you can't say that, oh, it was the old landlord that the enter into the agreement with the government. No, it runs with the land. So whoever acquires that land subsequently, also the terms are binding on that person. As an exception to, because if you go by the general rule, the subsequent buyer or owner was not part of the initial covenant that were entered into. So if you rely on the privilege of contract, you can say no. So, ladies and gentlemen, what I'm saying is that general rule is that, look, once you are not a party to an agreement, you cannot bring an exception. You cannot bring an action to enforce the rights or obligation that arise out of the contract. But then there are exceptions, and those exceptions are justified for the purpose of commercial or business efficiency. Because if you insist that it must be only parties to it, it will bring some, distortions and this, kind of inefficiencies in the dealings with, you know, uh, the market setting, and that's why that is the case. Very important, very very important. So take note of it. Now that takes us to another area of contracts. Do you have any exception on privity of contract? Any exception on that? Okay, so let's take us to another aspect of contracts which is illegal and void contracts. Now, one thing that you must note is that at the beginning of the class we said that for a contract to be enforceable, what must be present, if I may ask? For a contract to be enforceable, what is required? I'm asking the class.
Offer acceptance.
Go on, I'm with you. Hello.
An offer, there needs to be an offer. There needs to be also an acceptance for the offer to be binding. Those are part of the considerations based on some of the information you gave us
If I
earlier.
remember, sir, I think there's also capacity.
Okay.
Yes, there should be consideration and intention to create legal relation.
Okay. So if you go by that alone, you will discover that if you stop at that level, what I mean is that once you have those five elements, offer, acceptance, consideration, intention to create legal relations, and valid capacity. So you just think that once you have those elements present, then you can always enforce the contract. No, there are some factors that can destroy a contract that has all elements. What I mean by destroying is that that contract cannot be enforced because the essence of going into agreement is that if the person breaches the agreement, you can take legal action against that person. Now, but you have a situation whereby there are some factors that will destroy the agreement such that in the eyes of law, it will be as if there was no agreement between the parties at all. And so if the law deems it that there's no agreement between the parties, it means that they cannot enforce it. Now, of course, there's many of those elements, there are many of such elements. You have mistake, you have misrepresentation, where the person failed to disclose all information that require that subject matter or contract, as the case may be. You have duress, you have undue influence, and then you also have what they call illegal and void contracts. Illegal and void contracts. So we're looking at one of them, which is illegal contracts. Illegal contracts. Now, um, so for you to appreciate this, when you say illegal contract, for you to appreciate this, what do? Take out the word. Take out the word. You need the prefix il. So a contract is supposed to be legal. Supposed to be legal. But when you say that contract is illegal, it means that that contract is against the extant laws. That is, the laws say, don't do this, don't do this, don't do this, don't do that. But you're going into contract against what the law has provided. It could even be that the law ever prohibits such contracts. It could be the manner in which that contract is formed. It could be illegal at the time of forming it, or it could be a contract that was legal forming it, but the manner in which it is performed is illegal. So it could be legal at the time of forming the contract, or illegal at the time of performing that contract. But what we're saying here is that look, the once a contract that has all the elements, but then it's against the laws of that country or the nation or Nigeria, then that contract is not enforceable. So what I mean is that as businessmen and women, if we're going into a contract, make sure that that contract do not violate the rules or laws of Nigeria. And note that ignorance of law is not an excuse. What I mean is that once you're a Nigerian, it's presumed that you know all the laws of Nigeria. So you can't say, oh, I didn't know that the law says so. That cannot be a defense. So as businessmen and women, ensure that any contract you are going into, that contract is not against the laws of the country. Otherwise, that contract will not be enforceable. It means that you don't have anything at all before the law. Whereas you would have signed a document, sweat, sign, and even give thanksgiving. So the court tried to do that. Why? Because three grounds. Three grounds. One is unwillingness of the court to aid such contract. The court is unwilling. The court is meant to promote legality, not illegality. So how can a contract that's against the law, the court will now be helping you to enforce that kind of contract? It's not possible. And of course, if the court does that, then justice will be tainted. People will not have any integrity. The court will not have integrity anymore. People looking at the court as something that, you know, it also could be that in also not saying that such contract not enforceable is to discourage illegal enterprises. Otherwise, people will go into so many unlawful enterprises, and then they'll go to court, and the court will protect that same person. Like the case of Everest and Williams, those criminals that went to court to rob a bank, and one of them that was not given his own share, that went to sue others in the bank. I mean, sue others to get his share of the robbery. It means that you can go to into the robbery. Of course, if that's anything happen, you go to court, run to court for protection, which is not supposed to be. So, um, yes. So the court will not. So illegal contract, I say, is when the subject matter of the agreement violates the law or contrary to public policy. You know what that policy, it could be law or that behavior that the society upholds. If you go against it, even if it's not stated in law, because such contract will not be valid. Now, as I said, it could be illegal when the subject matter of agreement. So subject matter is that which is the core thing that the terms of contract are written around. So if I may ask, so just know whether you know the meaning of what's the subject matter in the context of the agreement between the student and University of Lagos. What's the subject matter? In this class, what's the subject matter between you and University of Lagos? What is the subject matter?
Certificate.
Certificate. I know say you know. Eh? Because all of you, that's what your mind is certificate. Like, this man, why are you wasting this thing? Just give us certificate. We want to get promotion. Who answered that question? Let me know the person that answered the question. Eh?
Teresa Odiakasa.
Yes, of cancer. Barrister Teresa. Yes. So your mind certificate. Yeah? You want that quick. That's the subject matter. So you see that subject matter, if you go into, there are so many terms. You must pay school fees, you must write exam, you must go attend evening class, this and that. Okay. But then you ask yourself, yeah, go to Shomolu and print the certificate. Hey. So you see that every contract, assuming that you enter into a contract with the University of Lagos to go and forge a certificate for you, that subject matter of the agreement, that forgery of that certificate becomes illegal. So what I mean is that if University of Lagos do not forge that certificate for you, you cannot even sue the University of Lagos. Why? Because the act of forgery is against the law, because the law prohibits forgery. So every contract will have a subject matter. Right. So you have examples of such contracts. Contract to commit murder. As some people will say that politicians will give money to go and give other money to go and beat up the opponent. So if you give that person money to go and beat your opponent, or I also know of some couples. There was one woman in Abuja that gave money to some boys to go and beat one lady that was disturbing the husband. Those agboro collected money, they didn't do anything. Now you cannot go and sue. You cannot go and sue them to recover the money because what the subject matter? Go and beat somebody, and I didn't beat the person. You are not suing that you refund the money. Becomes a problem. Sale of drugs that are prohibited, prostitution, right? Prostitution. In many cases that that someone is a prostitute. You gave that person house. You gave the person your house as a tenant. You know she's a prostitute. Now she has not paid you. She was coming in to use that house for the business of prostitution. You gave the house. Now, no customer comes in. He's not paying rent. You are suing. Where do you want? You can't get any benefit. Or you supply clothes to a prostitute to go and use it for her business. She didn't pay you back. You want to sue her. Which court will hear you? Gambling. Hardly on underage workers. The age of work, contract age is 18 years for under Child Right Act. For University of Lagos undergraduate, contract age is 16 years. Once at 16 years, you are qualified to enter into a contract with University of Lagos for purpose of admission. 16 years. So the age varies and all of those ones. So those are examples. There are many of them because, and the consequences of illegal contract is that that contract is void ab initio, void at the beginning, void in the sense that in the eyes of law, from at the beginning, the law take it that there was no contract, there was no relationship between the parties at the beginning, nothing at all. And that's why the maxim of ex to P concern no orator action apply, that no action can arise from a base cause. You cannot bring an action out of illegality. You cannot claim to enforce your right out of illegality. So once anything that violates the laws, or any contract that is void, then it's deemed that at the beginning of that contract is taken in the eyes of law that nothing existed. So you have those examples there, where people have used the defense of illegality to escape, those. Someone should read Everett and Williams. Yes, someone should read that case. Everett and Williams is one of the cases that I told you
And
before.
good evening. Can you hear me?
Very well.
Okay. An armed robber,
Barrister
Everett
who?
and
Barrister who? Introduce yourself
Mary
properly.
Jane. Mary Jane.
Mary J. Of cancer. I remember you are in court last week too. That's true.
Yes, sir.
Okay. Go on.
Everett versus Williams. An armed robber sued his partner to claim his own shares of their loot, valued at £200. The court declared the writ as scandalous and impertinent. The solicitor was fined for contempt while the parties were executed.
Exactly. They just, how can you go and rob a bank? Because they had an agreement that, you know what, we're going to commit on, we'll go and rob this bank, we'll pack money and pack jewelries. Then they now agree on this percentage on how they will share it. They went, had prayers, and robbers also pray when I go for this kind of thing. This God is just now. Wow, God is just God. Kai. Okay. Now they went down and were successful. So he was claiming that they did not give him his share as agreed. And a lawyer went and filed a writ of summons on his behalf. I just asking, I was curious that if you are the one, what do you do? Florence, if you are the one that you are a judge and these people come before you, what are you going to do? Florence of cancer. Yes. I'm asking you a question. Ah. Who is Florence in this class? I can see the name there. Nobody's talking to me. Ekene? Okay. Me too. I'm not going to talk again. Who is a class one in this class? Is a class captain in this class?
Good evening, sir. Yes, I'm here, sir.
Or SARS, if I call someone's name and the person not responding, it means that person is not part of us. You remove the person.
Okay, sir.
Because I see some persons are on here, and I'm calling the name and nobody's answering me. That means they are ghosts. They are not, because they just appear to get attendance. They are not part of us.
Apologies, sir. So I think they're on the road. So, but noted, sir. Noted.
Oh, road. Okay, so I can also be on road and also give the same lectures. So.
Apologies, sir.
No, I'm not angry now. Why are you apologizing? Someone that came here, I assume that is in class. So you are telling me that the person is on the road. Now, if that affects your result now, you're saying that, oh, you are all attending lectures. Attending which lectures? You're not attending lectures. You're on the road. You just log in for pretending. That is pretense. You know what is pretense? You are pretending as if you are in class, but you are not.
Against the law.
Yeah, they are not in class. They're not pretending. There's a login. Where I am, I'm logging. Let me log in and let me log in for this man. Leave him. That is very wrong.
We'll lock them up, sir.
That's quite very wrong.
Good contract.
Yes, sir.
My lord, they are in class, but they're not participating. There are two things.
No, what do you by participate? I'm calling. I saw some names on my screen, and I'm calling those names. It means that they're in class. So I want them. I'm drawing their attention to participate, and I'm asking a question: what can you do? Oh, they ignore me. Are you saying they're also ignoring me? Is that what you mean? They don't want to participate in the class? Okay, no. So that's it. So that was what the court heard. The two armed robbers were executed. They called them. They will kill them, and the judge, the lawyer that took them to acted on their behalf, was also fined. As the case may be. But then there are, of course, situation whereby contracts is valid at the beginning, but illegal at time of as time of performing it. In which case, the court can also decide based on the circumstances of each case. So, as I said before, when you say the contract is void, is the one which the law will disregard, the law will not recognize it, the law will not allow you to sue or enforce any right that comes out of it. It may involve immorality or any attempt to break the law. I'm giving those such examples, like where you are manufacturing or marketing, you are employed to market a product that is without NAFDAC's number. It's in violation of it. So of course you are employed as a marketer, but then because of that, it cannot be enforced because you employ someone to market, a fake drug because of no NAFDAC number, and the person refused or took money for you and did not do that. You can't sue for breach of contracts. A typical example is the case of Savannah Bank Agilo, which requires the issue of um, yeah, I saw in hand up here. Is it Kingsley of Cancer? Chibozo?
Yes, my lord.
Yeah, welcome.
Yeah,
Your hand is
I have a
up.
question. Yes,
Okay.
my lord. I have a question.
Go ahead.
Since we're talking about illegal and void contract, my question has to do with marriage to minors. What does the Nigerian law say about situations like that? Especially when we have situations whereby up north, they have their own definitions for minor, and down south, we have our own definitions for minor. What is the position of the law as regards that? How does the law interpret that when they begin to look at the Sharia law and at the same time look at the Nigerian law
What's
together?
your intention? Chibozo, what's your intention? You want to marry in the north? Disclose full facts. So I want full disclosure.
No, I just want to understand the position of Nigerian law as situations like that. In situations
I'm
like
just
that.
joking. I'm just joking. It's very simple. When it comes to marriage, it depends on under which law are you marrying. So if you want to marry under English law, the age for English law is, as I say, contract is 18 years above. Under common law is 21 years. So once you're 18 years above, if you are married under English law, the one that you go marry in court, you go and marry in court. You can't go and marry in court when you are less than. That is English law. But if you are married under customary law, then customs, they have different measure of maturity. And so some customs, like those what we are mentioning now, they do in the way that different customs to it. But I know that one of the issues that is the age, they say the age of puberty. That is when a woman experiences her first menstrual period. In some custom, they know that, oh, that woman is right, is due for marriage. Because we're married. That's so all this man you're talking about, that marriage under customary law, that is Islamic custom. That's what the old custom says so. Now it may come to Igbo land or come to Yoruba land, the custom may differ. But in most cases, what I'm saying, they measure it once a lady have seen her first menstrual period, is deemed that lady is right for marriage, and they don't That's one. And then of course they also say that in some custom, this custom I'm talking about here, that look, if the marriage is a cost is a minor, then what they need is just the custom, they need the consent of the parents. So it's not at that, because they know that that child cannot grant consent. They don't know what she's going into. But once the parents have said yes on her behalf, then she had no say. So that is based on that custom. So you have to distinguish it between the customary law of that person that you're talking about and the English law, because there are all type of marriages, in Nigeria. They are all recognized. That's why for those minor you're talking about, like the one that former governor of Zamfara State that was marrying people age of 10, 12, even Sanusi did the same thing. But if they ask, because the law say go and ask the parents. When they ask the parents, say no, we consented, and that's why nothing happened thereafter. There was some NGOs that don't want to make noise. It didn't go anywhere because that is the custom.
So under the Nigerian law, do we say that is illegal, or do we say that's a void contract?
No, it's not. When the marriage is under customary law, that's not illegal because it's a custom. What happens that for a custom to be acceptable, there's what they call repugnancy test. So until you denounce that custom, until you go to court and denounce that custom, it's acceptable as a measure of behavior based on people in that community. What could be a custom in one community we're not binding on. So you that is in your own place now, if that is not a custom in your place, you cannot give someone in marriage at that age. So law doesn't have the fact that it's being done in one state doesn't mean that law will be done applicable to all persons in Nigeria. No, it's once custom.
So invariably, sir, you are saying that if the custom,
yes, if the custom of that those people permit it, what they're doing is not illegal. Remember that rules of custom are also sources of law. I don't know whether you did that before when you are doing when Prof was teaching you sources of law. I don't know whether you did that, but sources of law is just a big umbrella that has rules, different rules inside for different issues, and all these rules put together they say law. So even in Nigeria, what could be law in Lagos State might not be law in Zamfara State. What could be a law in Zamfara State might not be a law in Lagos State. So it varies. But then if we're talking about sources of law, customary law, Islamic law are all sources of law. So even as businessmen, if you go to Zamfara State as a banker, is what if the law of Zamfara State say that you as a male banker cannot deal with a female customer, you cannot. If they say that in Zamfara State you cannot wear trouser, as a lady you can't wear trouser and go to bank or go to office with trouser. If there were laws that say in Zamfara State, you cannot try that. But if you come to Lagos State, and you are posted Lagos State, you can wear trouser and go to office. But if Zamfara State say, look, you can't wear trouser and go to office, you cannot, even though you're working with the same First Bank. So customs are sources of law, just that they're only binding to people that are in that custom only, where the custom apply. That's all. But they are sources of law, and they are accepted as binding on people within those customs.
So, sir, are there situations whereby this customary law contradicts with the federal law? And in such situations, what law will now prevail?
What do you mean by federal law? Which law? Which law? Just mention one. Mention one federal law that you're talking about.
Okay, what I'm trying to say is, for instance, now there are some customs that accept smoking of Indian hemp, and the general law is like Indian hemp is not acceptable. It's not good to take such, especially as regards NAFDAC and all those kind of things. So
there's what they call occupying. There's what they call occupying the field. Doctrine of occupying the field. Doctrine of occupying the field is that when a state government enact a law and federal government enact a law on the same subject matter and the law are conflicting, then the laws of federal government prevails based on doctrine of occupying the field. So you have to be specific about which subject matter that the two of them enact a law on. So there's no law in Nigeria that prescribe. There's no federal government law that say that if you are marrying you're marrying any person, is the person of this age, whether you are marrying under customary law or you are marrying under English law. What the law says is very simple, that you can choose to marry the one that you want to marry. You can choose to marry under Islamic law or customary law, or you can marry under English law. So the choice is yours. They didn't talk about that you must marry under this particular aspect. I hope I'm making sense to you, Kingsley of Cancer. Kingsley.
Yes, I agree with you, sir. Thank you, sir.
Okay, all right. So back to the business. So at the case of Savannah Bank, for instance, and the issue is about sale of land or interest in land. By the Land Use Act, all the land in the state belongs to the governor of that state will hold the land in trust for members of that state. So all the land in Lagos State, the governor of Lagos State is deemed to hold all the land in trust for all of us that are in Lagos or Lagosians, as the case may be. So what I mean is that if you want to transfer land, if you want to sell land to another person or transfer interest in land into that person, you must obtain governor's consent. And the governor also can take your land from you, can take the land from you for public interest. As you will hear many instances that they have destroyed so many estates in Lagos because they want to create water channel. That this flood is disturbing, and so that some people have built houses which is private on water channel. So they went to destroy so many estates in Lagos like that. Why? Because for public interest. The government can also take over your house and convert to a general hospital for public interest. What you need to do is that once you have necessary restriction, the government will pay you compensation, adequate compensation for taking over your own private property. But what I'm saying that you cannot transfer before you say you transfer a valid title from land. So if in Lagos State and you are the owner of a land, you want to sell that land to another person, that deed of assignment must be registered with Lagos State and consent of the governor must be obtained before you have a valid title. That's why most people that buy land, you say, have you obtained COO? COO cannot be issued if there's no governor's consent. And if you don't have those COO and the government wants to, just imagine that time that they were doing was constructing the road from Lagos to Badagry, that Badagry road. They destroyed so many properties from Oshodi, right from Oshodi. And what happened? They will only ask people that if you have any CO, bring evidence of receiving your land or house to Lagos State. Those that had it were compensated. Those that did not have it, that was the end of their having property in Lagos. So also advising you as businessmen, if you have any property in Lagos, please go and register it with Alausa. If you don't know how to go about it, you can meet us privately. We'll support you on that. So if you look at Bank Agilo, for instance, if a mortgage, those are you that are bankers, people will give you property as collateral and take loan from you. That mortgage must be registered. Governor's consent must. So once the mortgage itself, that mortgage is a legal document. But if you want to enforce a mortgage, there's a procedure also required by law. So you may have a legal mortgage, but if you follow wrong procedure to enforce that mortgage, then the court will deny you. So this is what happened at Savannah Bank and Agilo. They didn't obtain governor consent. They just went through the back door and wanted to take over the man's property and say, because the issue of mortgage is that if I did not pay back the loan, you can use this collateral property to pay or manage it and recover the money that I borrowed from you. That's the whole essence of mortgage. Now, but you can't use that mortgage to take someone's property from the back door. Bankers in the house. I hope you are listening to me very well. Do we have bankers in this house? There are many of them. Osas, how many bankers? Glory is a banker. Chioma is a banker. Show is. I'm looking at names that I can see on the notice on my screen. Abdul Oluwasegun is a banker. Kashim, Tony is a banker. All of you that I'm scrolling your name, you're all bankers.
Sir, you are right. Oh. Absolutely.
So you see that you bankers pay attention. You don't just because you use the back door and take someone's property because you are eyeing that property, so you can go and open one of your branches there. You can't work that way. You must go to the procedure, and that's what happened. That was what happened there. Illegality. Another aspect that's very very common is contract in restraint of trade. Someone employed you and is saying that look, that even if you leave the employment within 2 years, you cannot have dealing with any other customers, you cannot practice the same business, you cannot use the same ideas, you can't use the same thing that until after 2 years. In fact, even foreign company, the one time if they bring expatriate, they will still those expatriate you cannot even work in Nigeria until after so number of years. So you are enter into a contract of employment whereby you sign that you will limit your future liberty. You have liberty to work with any person you want to work. That's the constitutional liberty. You have the fundamental liberty. Choose who you want to work. Now you are saying that you will not work with any XYZ in future because you're working with this person presently. Contracts in restraint of trade, profession, business. So you agree not to compete because you want to get that job. Do we have someone in this class that's in that kind of situation that have signed that kind of agreement in this class? Do you have any person in this class that has signed that kind of agreement that you have signed that you're not going to do this? You're not going to do that? Do you have any person in this class that have signed such agreement so that can share their experience? And then we'll tell you what the law says. Nobody. Osas, do you have anybody in this class that is in that kind of situation?
No, sir. No, sir. No, sir. Okay, someone's hand is up. Mary Jane also.
Okay, Mary Jane of Cancer, yes.
Okay, so I just want to relate an experience with my former place of work. I don't know if that's fine.
Go ahead. You are protected.
Okay, so my former place of work, there was a time they gave us bond to sign. Just few of us. They said for 4 years, we're not going to leave the company. They are going to be working with the company. And the man made it mandatory that we must sign the bond. Well, every other person signed besides me. And then he called for a meeting. I just told him clearly that I'm not going to sign the bond. He said I must sign the bond. Then I tendered my resignation. When I tendered my resignation, he said I must not resign. And I was like, I don't know. So I was like,
serious.
that was
Is the
something
man
very
that
serious. So he said he cited some instances of where he invested money in training and all that. But I told him that's not grand enough for me not to resign. It was something big, but eventually I left the company and I'm here. So I would like to hear, is there anything that the law say pertaining that, like forcing people to be in your company, probably because you spent little money on them or something?
Yeah. So that those are the things. So the issue, that's what we're going to by the time we look at what the law says, and then we'll come back to your question. So the issue is that when such agreement that are entered into, are they illegal? Are they contract? Are they void? Or are they enforceable? That's the question that we're trying to answer here. Such agreement, are they enforceable? Can someone, after signing that bond, for instance, and you breach it, can they go after you? Is it lawful? Can they enforce their right? Can they ask you to compensate them or more? So now, initially in the past, that's in the past means the old law, or the position of the old law. Under the old law, the position was that contract in relation of trade were void, prima facie, on the face of them. Prima facie is on the face of it. They were on the face of it void for reasons of public policy and also to discourage monopolies. So if you ask someone to work with you and you alone, it means that you are trying to create monopoly so that you don't have people that, this person has skills, so you don't want him to go and share such this with someone. Now, but at the same time, that old law at the point was challenged, and then the courts have to shift. The courts have to shift. The law have to shift to create a balance between protecting the owner of the business and protecting the interest of the employee. And how do they do? They now introduce a requirement of reasonability. Is it reasonable? That is, can that restrict, is it that restriction on your practice, that restriction that you must not work with, is it reasonable? And if you say reasonable, reasonable for who? Whose interest? Is it the interest of the employer or in the interest of the employee or against public interest or in the public interest? So this is where the court is now. So unlike the past, the old law that look, oh, such agreement avoid, oh, they avoid, oh, avoid. Now the court has to balance it. Is it void? Is it reasonable? So what I mean is that who alleges if your company now say, look, oh, that bound is reasonable, then they must prove. They must prove to the satisfaction on balance or probability how that is protecting you or the interest of the company. On the other hand, if it's you that is saying that it's reasonable for to protect you, you must also bring evidence that you know that will help protect you. Just show. So just as I was saying, that he who allege must prove. If you allege, you must prove. So the question is that when it comes to bound, this what they call novation. That is, you have entered into a contract with someone. Now, but in the course of it, you want to introduce a term or something that was not part of that contract. What I mean is that if you accept that new term, it means that you are amending, you are kind of, kind of altering the old agreement or novation by bringing new terms that were not there initially. So in the question that Merging of Council asked, for instance, those pounds that they asked you to, they were not there at the beginning when you are going to that contract, when you assigned the contract of employment. They were brought subsequently. So you have a discretion to accept or reject. If you do not accept, no one can do anything. Because the training that we're giving you, because most of them will say, did you sign in the agreement that the training that you're going to acquire, that after acquiring those training, you will not go anywhere, you work with the company, because by training you, the company needs those skills to be applied, to be useful to them in the context of what they are. If that is the case, if I signed that way and that was why you are being trained, then of course you have to pay back. Otherwise, they will sue you. They will try to get a compensation from be compensated. But if it was just normal training, if that training was done as part of the responsibility of the company, that they had agreed that in the course of employment they will training you from time to time. If that is a responsibility of the company that they will train you from time to time, that's a different ball game entirely. In that case, just training you per se has no link whatsoever with the bond that you are going to sign, except the bond will link with the training. So, and this, for whether or not the facts and the training is linked with the bond, is a question of fact. Is you that will know. Is what you would have known before. It's not a question of cooking scenario. No, you can say no, but that's what they told you. This is what you were signed. This is what you know it. Not just about cooking a story to make up for what you have done before. So meridian of cancer, that could be the answer for your own. So it's a matter of fact. You have to check it yourself. If they are not, if the training was not for that, then they can't just come and say, "Oh, I train you." I train you. What do you say in the agreement? On the agreement, you said that you will train me. Those train that I need, you will. So in the context of when it comes to living a particular trade, contract in resting of trade, for instance, there are some people that top management, they know the trade secrets. They have link to all the customers, such that if I allow them, they will just go and open the business and move away with all these customers and start their own business, and then your own will collapse. Your own business will collapse. You see that if that's the case, people will find it going to ever employ, because they believe that people were afraid that if I employ someone, the person will come and kill my business and go and start his own. And so government will not want to promote that kind of behavior. And that's why there's a balance. The question of reasonability. Is it reasonable to allow this contract and resting of trade to stand? If it is reasonable, you bring the facts that shows it's reasonable, the court will grant you. But if it is unreasonable, the court will not grant you, will not enforce it. the same thing to a customer, or the same thing when the public interest is involved. So you look at the case of Nigerian Textile Mills Limited. Of course, the manager was that manager. He was a senior manager. Leon Retis was a senior manager. He was top, even though he was working in Lagos. They stopped him from working any textile mill in Nigeria, the whole Nigeria, for 2 years. He went to court. He didn't succeed because then that's based on his position in the company, and of course the area of means were the business in those days at the time of this case. They stopped him, and the court cannot work with any similar company for the next 2 years. It was successful. So, as I say, it's a question of fact. You must prove it. It will prove successful. The court will listen to you. If not, the court will not listen to you. Yes. So, Jane of Cancer, that is just a response I have for your question.
Okay, that's fine, sir. Thank you.
Yes, Barrister Olua Damilola.
Yeah, good evening, sir.
Go ahead.
Yes, sir. I have a question as regards the last comment you made for the contract with the company. So my question is this, sir.
Yes.
Where a person was asked to sign, at the point of the contract and to get a job. Now, in the process, probably after 2 years, the contract says that you cannot work anywhere else until after 2 years that you've left. You cannot go to a competitor's company to work.
Yes.
But then in the contract was terminated by the company when the person was found guilty of some misappropriation of fund and all that. My question is this: can that person still go ahead after being sacked to get a job from the competitor?
No, the fact that the fact that no, the issue that when you leave, they didn't talk about reason for leaving. The reason for leaving the company is different thing, because the person, even if the employer is not terminate for misappropriation, the employee also can also leave for whatever reason. So because there's no law that says that the two of them must remain together forever. No, it's the aftermath of that togetherness that the law is looking, is the future one that they're looking at. If we're working together, no, the law doesn't bother about you want to leave, you can leave. That's not a problem at all. The law is not stopping. There's no law that says that you must. In fact, the saying is that the law is that you cannot compare a willing employee on an unwilling employer and vice versa. So if the employer is unwilling, you cannot force a willing employee on an unwilling employer. That's what the law says. So if he wants to go, fine, there's no problem. So if you are, there's no, you are embezzling money, or why should I keep you? You run down the business. So, but then when you leave, what happened? Don't work because of where you are, the position that you are. That's the truth. And look at the example that you gave. Even is someone that has to be prosecuted. Somebody has to be prosecuted because the issue is that you can't say that someone embezzled. You can't establish embezzlement unless the court so pronounced, or the person would have considered maybe in the disciplinary committee of that company, as the case may be.
Okay, thank you, sir.
Welcome. Okay, so we're moving to another stage of the contract of discussion now, which is discharge of contract. Discharge. When you say a contract is discharged, you are saying that the contract has come to an end. Everything that has a beginning must have an end. You are one is MBA student, one day you will cease to be, and then you have certificate. You don't even know me again. You don't know one man. There's one man that will teach us law of contract. What is that name again? That's why you stop. Even Osas, as the class governor, will not even know. Who will remember me? Because in fact, would you ever remember to call me and invite me on your graduation day to come and eat rice? No. You will just be celebrating that I got it. I got the MBS. I got it. You will forget me completely. less life, no balance. So, Osas, are you hearing me?
Yes, sir. Yes, sir. I'll
That's
surely
why
invite you.
you know, this one you're just talking. You're not talking. When the day comes first, whether you ever remember say a day. So I know that some of you after graduation and you go say, I forgot to. This man was saying it to. So that is just so everything that has a beginning must have an end. You know, I would have loved to teach with you, you know, because once I'm in class with you, I feel so happy because I'm trying with so many lawyers from different backgrounds. I enjoy it. But then the class must end now. Say you want to stay in MBA or forever. No, please, oh, it's time for lectures, time for it, so that you can have your MBA, be happy, enjoy your life, right? So contract also come to an end. Even in the employment sector, their age, even if you don't want to retire, when you use a particular age, you must go. There are other factors. So even in the remember that when we were discussing offer, we also said that an offer can also come to an end. I will give you various ways by which an offer can come to an end. And I hope you will not mistake that if a question is asked about this in exams. Eh? So how many ways will a contract come to an end? How many offer ways that an offer can come to an end? Methods through which an offer can come to an end. Do you see remember them? It's been a long time that we said it. Very long time. I don't know whether you can still remember it. Huh? Who can remember it all? Nobody. Well, I do.
By the tenor, once the tenor elapses, the offer can come from.
Which tenor? Okay, expression of time.
Yes,
Is that
once
what
the
you mean?
tenor of the offer elapses, the contract
Okay.
can.
That's number one.
I think when you present a counter offer, I think you
Yeah.
said when
That
salaries are
one.
being, yeah.
Yes. A counter offer destroyed the original offer. Yes.
When the offer has been fully executed or discharged, it can also come to an end.
Offer. How can you discharge an offer? I don't understand.
I mean the contract, for instance, a loan contract offer and the customer has fully paid all the installments, the contract can end at that point.
I say offer. Is offer a contract?
Oh, sorry, I thought you were talking about contract.
No.
So we also have revocation.
Revocation.
When,
Correct.
okay.
Correct. Revocation. Yes. Who
When the
revokes?
conditions of the offer are not met, the offer can also elapse.
Those are the same thing. It lapse now. That's the same thing. Conditional offer. Yes.
Rejection. What about rejection?
Rejection. Correct. So you see that, and the other one about debt and all of those ones. So, but just to tell you that those are factors that terminate an offer. Now we're looking at factors that terminate contracts. So when you say contract, it means that offer acceptance, all those elements are already there. And so there are four ways: by performance, by agreement, by frustration, and by breach. By performance, you know, when you carry out, because that's what the contract does, you carry out your own obligations. A contract is entered into, you carry your obligations. Simple. Just that the rule is that, you know, when if you are to construct, you must do that construction exactly. If you are to supply goods, you supply those goods as stated in the contract. If you are to provide consultant services, you provide those consultant services as provided in the contract. So what I'm saying in essence that look, there's always that you know, there's always that you know provisions because the terms of contract are always there. Remember that when it said that offer, when offer is at the time of making offer, you know, this it must contain terms, and it's the terms that once accepted it becomes a contract. So a contract it starts you start creating the terms of contract at the time of the offer is made and accepted. So you know, it's those terms that will tell you, okay, what is my obligation? Like University of Lagos, what are the obligations of University of Lagos? For students, what are the obligations of the students? You know all those things. So it means that you must, you know, do that exactly. Now you have what is called substantial. There are exceptions. Exception whereby even the performance may not be exactly be sufficient. And then when you have issue of substantial performance. Typical example is lectures. Our lecture is supposed to start exactly at 6 o'clock. Exactly at 6 o'clock, and exactly at 8 o'clock. There are sometimes that we start beyond late in 6. Sometimes we extend before 8. We extend after 8 o'clock. But in all of this, if you judge everything, you see that there's substantial compliance. There's substantial because you could all say, no matter he came, he still came. Lectures went on smoothly. We had lectures, blah blah. So in fact, the issue of substantial compliance is a language of elections in Nigeria. When someone wins election and the INEC is called upon, and they will say, there was substantial compliance. Even when the ballot boxes will be hijacked in some places. Say, no, there was substantial compliance. So it's not left with that saying there was no substantial compliance to prove it. If you cannot prove it, the person that will declare the winner remain the winner as the case may be. So there are many of such services. So, you might not do exactly as provided, but then they substantially would have done it. That is okay. Now, where it is, like for instance, maybe construction of a building, and the person does it. What remained was just minor painting or sockets. You may accept that and get compensation for those ones that remain undone. As case may be. Several contracts in construction, for instance, those of you that are into construction, you see that or supplier, all those things. You may enter into agreement with someone that for for a year he's the one that you'll be supplying those drugs to that pharmacist or those provisions in the supermarket, as case may be. Anytime the invoice is presented, you supply. Anytime the invoice is presented, you supply, and all of those things. So several contracts. Each of those contracts is a contract of its own. So in a building, you lay a foundation, that is a milestone. In building, they use language of milestone. If you lay a foundation, that's this payment is made at that level. If you do the first floor, they do payment at that level. So sometimes if you don't pay the second part of it, then they abandon it. That's why sometimes you say abandon project. They abandon the project. That is why, because this another phase that was supposed to carry on, the other part did not perform their own obligations. All of those ones. Or where there's prevention of performance, where the one party want to perform his contract, but another party prevent that party from carrying on the contract. Then of course, that also is comes under performance of the contract. So the essence of going into agreement is that you will perform your obligations and I will perform my obligations. So once those obligations are performed, the contract comes to an end. Although you may have, as I said, exceptions of substantial performance and several, those are with respect to exceptions to the rule that parties must perform the contract exactly as provided for in the agreement. So what I mean is that for University of Lagos, at exactly 6 o'clock, all of you would have been in class. But even at the time that we log in, we had less than 15 people in class. That means you need to come exactly 6 o'clock. Now we have up to 90 people here, who came after that. It wasn't exactly. Yet we didn't send them away because you were required to be in class exactly 6 o'clock, based on the terms of the agreement. So that's for it for performance. Then you also have agreement. So just as parties we agree to go into a contract, they can also agree to go away. Husband and wife stay together under contract of marriage. You can say, you know what, this marriage cannot work. Oh boy, this thing cannot work. Better go your own way. May I go my way? They don't go be that. You want to supply, this consultancy cannot work. You go, I go. Just agreement. Or you bought something, you brought it back. Someone has supplied something to you. You say, no, I can't take this one. Please don't take it and give me my money. You agree. There are many reasons to that. Oh, I have it before, I don't need it again. So the way you agree to come to a contract, you can also agree to discharge the contract to go. So you also have the third type. Do you have any question? Do you have any question? Just one that's straightforward. So, do you have any question? No question. Okay. Discharge by breach. Yes, someone's asking a question. Mariam, you want to say something? Okay,
Can I ask a question, sir?
go ahead.
What of a situation whereby one of the party dies and probably there is no insurance to cover that aspect? What happens in that case? Can we say the contract can be discharged at that point?
Of course, that is frustration. That's one of frustration. We're going to discuss that. So it also depends on the nature of the contract. If the contract that can be carried on by representatives of the party that dies, why not? Contract is not terminated.
Then,
But it's
sir,
only but it's contract of personal service that require personal service of that person. So if you've gone into liquidation or debt, then of course you cannot go. Yeah.
So how do
Because
you address the case whereby the party involved, for instance, illegal mortgage was involved, and the party, the obligor now dies? Will the bank push to recover the assets to repay the
that's what we're
person?
saying now. That's what we're saying. If a contract can survive the debt, you know that some contract can survive the debt. So if the mortgage, even when you die, do they bury you with the property? Someone is going to inherit the property. So the law is very simple. If you are inheriting the property, that's the benefit. You also take the burden. You can't choose to take only the benefit and leave the burden. So if the property was mortgaged and the person died, and you are the one that will inherit that property, you can't shave the mortgage away. No, to just enjoy the property. No, you take both the mortgage and the property, and you know how to manage it. That's
So
just
how
it.
about the situation whereby there's a mortgage assurance in place to cover such kind of risk?
The insurance
Will
company
the-
comes in. That's why insurance company are there now. That's insurance company comes in and they pay whoever. Insurance company takes care of someone's responsibility. If that was to happen, who is supposed to bear the loss? The insurance company comes in and pay the loss to that person. So that's what it does now. That's what they are paid to do, to manage to take the risk of others when they will call. That's all.
then, my lord,
Yes, go on. A building of cancer.
under the privity contract, sir,
Yes.
what if the one party died? Can the next of kin, sue if the other party do otherwise?
And that's the same thing with what Kisley was asking now. There are many cases in the insurance company that is the person will die and the third party, the person that survives, is the one that will now take action to go. There are many cases like that. You know,
All
there
right,
was
thank you, my lord.
yes, there was a case that one of the insurance cases that where this man was it gay and who, where the insured took a life insurance policy. That is the customer took life insurance policy. And one of the clauses in that agreement was that you know yes, they had this life insurance policy, right? And one of the clauses was that the person that is the insured will be compensated even if he commits suicide. you know so true to that, the person committed suicide and the survivor now sued, the wife now sued, and the question whether the wife should be compensated or not. So we have cases like that, many of such cases like that, where people will sue after. There was even a case of a woman that um, you know there was this man that was dating another person's wife. I don't know whether you heard that case. This man was dating another person's wife. So the husband of the wife took the gun, loaded the gun, and went to this man's house to threaten him. Stop following my wife. Stop dating my wife. So he took the gun to that person just to threaten the man. Stop chasing my wife. So, but unfortunately, the gun now escaped. The bullet now escaped and shot the man, and the man died. Right? The gun was insured. Why they laugh now? Yeah. Serious matter. Things that happen. No. Yeah. So the wife of the dead husband now went after the insurance company to claim compensation, against the insurance company. The insurance company said, no, we're not giving you any dime because of the act of the person that did. So the question was, who exactly are you, whose interest? You killed that person's husband. Now you're saying that the wife cannot even benefit from insurance cover over the gun that killed the husband. But again, the issue was that whether killing, someone can benefit from the act of killing. You took the gun to threaten somebody. I will deal with you. Next time I see you with my wife, I'll deal with you. The bullet just escaped and kill the person. Well, I don't start. So we have many cases like that. There are many cases that the third parties are suing, after the person is dead, you know, many cases. Any
Thank you, sir.
Okay. I like, when you ask questions, I like it when you ask questions because it's only when the brain will be challenged to say something that would have escaped me, right? So I like lawyers that ask questions. So discharge by breach, opposite of performance. Instead of performing, you not perform, becomes a breach. So when you go into a contract, so some of you that you are working, you don't even tell your company that you are supposed to disclose to a company anything that you are doing in the course of employment. You came and got admission to read MBA in Lagos. You didn't tell you did not disclose this into your employers. Uh-huh. You are- And then sometimes you are on the system, you put your eyes on the system. They will think you are working hard. Oh, you are researching to do assignment. You are doing an assignment that they give you at MBA class. Osas, are you here?
Yes, sir. I'm here, sir.
Yes, sir.
How many people will look at the system, they will put their eyes on the system, you'll be thinking they're doing work in the office, whether they're doing an MBA assignment that they gave them in the class. Do we have some of them here in this class? Oh, oh my God. I'm not looking at you.
Someone
No,
raise their hand, sir.
if you want to remain quiet, no wahala now. Remain quiet.
Someone
We
raise
know
their
you.
hand, sir.
Which hand? You sit down and before me, your mate will be saying la la la. Whereas the assignment you are doing, bridge, you're supposed to work in, except those break time, bridge, and you don't want them to know. Twin, your hand was up, yes. Gloria said guilty as charged. I know you, I know you, I know you now. I will always get someone here. I know that guy will do it. They will say, Gloria is busy. She's always busy. Now NBA assignment that she's doing. It don't matter. Breach. You fail to perform the terms of the contract. Now, there are two types of breach. You have the actual breach and anticipatory breach. The actual breach is when you fail to carry out the obligations. Now, know that there are different types of contract. There are some contracts that you go into and you perform immediately. There are some contracts you go into and you perform in future. You go to a supermarket, you pay for goods, you take them away. Executed contract because those contracts are done immediately. But if you get admission to University of Lagos to get MBA certificate, it's in future. The certificate can only be given to you in future. So if University of Lagos not perform their own part, that will be breach. Now, the actual breach is the one that happened at the time the contract is entered into, and then the one that a contract that's to perform in future, where there's a contract between two parties to perform at a future date, performance in future date. And one party has shown either by words or action that he has no intention of performing that contract, then it is called anticipatory breach. Because of this person have done, It is anticipated that you will not perform this contract in future when that time comes. You have a contract to hire MC to attend your daughter or children or your wife or husband on the day of the birthday. You heard that this person has traveled to London a day before the event. He's already going to London. How can he go to London and then the following day he come back again to perform your event? So you see that even though the day of your event has not come, the fact that this person has traveled to London, it shows that on that day he will not show up. You applied to rent, get money for lease of a house or apartment. Another tenant is already moving inside the apartment. Lagos, I don't know whether you have that on Lagos style now. One landlord will give one apartment to 100 people. So it's first to come. Even land, they will give one land to 100 people. It's first to build that becomes the owner. Oh, things that happen for this Lagos. Osas, have you been following these things? One landlord, one person will give one house to 100 people. And just before this time, we're looking like this. Sometimes you see that tenant will fighting. You just laugh, say, this tenant, you are not learned. Yeah. Or you don't attend MBA class. If you attend MBA class, you will behave smart. You won't behave that way. That someone will outsmart you. You pay for rent on getting there, so that someone already occupied that place. And the person say, I just move in now. Hey, Lagos. Right. So anticipated breach. So the issue is that once you anticipate that someone will not perform his contract, you can also sue for breach of contracts. Another way by which a contract comes in is by frustration. Frustration. Can someone read that last paragraph? Can someone read that last paragraph so that we know you are all together?
Discharge by frustration. Can you hear, sir?
Yes, very well.
Okay. Parties to a contract discharged or excused from further performance. Sorry, I'm trying to.
Okay. Can you see the slide?
No, sir. Can you scroll up a little, sir?
Okay.
Okay, yeah.
Okay.
Sir, remove your cursor from the screen.
Okay.
Okay, yeah. Parties to a contract are discharged, excused from further performance of their obligations if some unexpected event occurs during the currency of the contract, without the fault of either party, which makes further performance impossible or illegal.
Go white again.
Discharge by frustration. Parties to a contract are discharged, excused from further performance of their obligations if some unexpected event occur during the currency of the contract without the fault of either party, which makes further performance impossible or illegal.
Exactly. So you see, if you can underline those key things there. So frustration. Frustration is a common word that people use. I'm frustrated. I've been doing this MBA, doing this MBA. I'm frustrated. No, that's not what we're talking about when it comes to frustration as a factor to terminate an agreement, a contract. We're saying that parties have entered into a contract. You know, you know, they enter into a contract. The difference between entering into a contract and performing the terms of that contract. There are two things. You can enter into a contract and not able to perform the terms of that contract. But the issue will be what exactly causes you not to perform the contract. This is where frustration comes in here. That parties are entering into a contract, but before they will perform the terms of that contract, an unexpected event occur. Unexpected, because if they shift liability, if they say, oh, if this event occur, this person will be responsible. This one's like force major. If we have an agreement whereby there's force major and the parties agree that local, if there's force major, then you are responsible. That's a different thing. That will not be issue of breach at all. I mean, it's frustration. But then they enter into agreement before they perform an unexpected event occur, not the fault of the parties, not the fault of any of the parties, yet because of that unexpected event, it becomes impossible for the parties to perform the contract. They cannot perform. But it is not the fault of any of the parties, then it cannot be frustration. Unexpected, if it is expected, if it is unexpected and is a fault of any of the party, that also cannot be frustration. So it must be an event that is unexpected and not the fault of either party. But the consequences is that it becomes impossible or illegal to perform that contract. So you enter into a contract for supply of drugs, then that particular drug, the government have enacted a law, a policy prohibiting members of the public from dealing with such drug. That law becomes unexpected event. So if you go on with any contract dealing with that product, it becomes illegal. But you are not the one that, none of the parties are the one that enacted that law. So it wasn't the fault of the parties. It could be act of God, fire, flood. The rain has fell all the night, have destroyed the warehouse, have destroyed your building. The fire has consumed the office space. You can't go to work because who brought the fire? It's not you, not the fault of either of the parties. So it could be war. There are many of such instances, and of course, such cases are destruction of subject matter and many of those things. So there are many of such instances. The case of fibrosa, you can Google it. Someone should Google that case, fibrosa case. Someone should Google it. In one of the examples, but there are many examples. Some are act of God, and some act of God is like what do you call it? Thunder, lightning, flooding. Things are natural, are done by or storm to remove the roof, or So it's a different entirely. If someone is giving you an office space, and the person know that the government is coming to demolish that office space they're giving to you, after you pay for the office, government has come to demolish that office. That cannot be frustration because the person knew that the place was going to be demolished before giving to you. That cannot be frustration because it's the fault of the other party. So, ladies and gentlemen, what I'm saying, look, frustration is all about those unexpected events. That's not the fault of parties, but because of that unexpected event, because of the occurrence of that unexpected event, it becomes impossible for the parties to do what? To go perform their obligation. So what happened? Two things happen here. If one party has started performing before that unexpected event occur, then that party will be compensated for what they have done before the unexpected event occurred. So the unexpected event is only for the future, what has remained undone or unperformed. So if one of the parties or the parties have taken some steps before that unexpected event, they will be compensated for those things that they've done before unexpected event. Is that which is advanced, that one which is ahead, that has not been done, that will cease to be done, and no party will be held accountable for that because the contract is deemed to come to an end. If you look at Fibrosa case, it was war. They entered into the agreement, then the war broke in between those two countries. So when two countries are fighting, there's no way that the private persons in those countries can do any contracts. It's not possible now because of war. So those are examples of frustration as one of the methods of bringing a contract to an end. Any question? Yes, and Mary Jane, yeah, of cancer, yes.
Okay, sir. So earlier when you were explaining this breach by frustration or discharge, I don't even know by frustration
Which
You
one?
said
No,
you
breach
gave
is
an
different. Breach is a different. It's a different method of breach is when you fail to carry out your own obligation. You
okay,
refuse.
yeah. So discharge by frustration. You
Frustration. You do not is the reason for not doing your own. You are ready. This one you are ready to do your work. You carry your obligation, but something happened that is not your fault. But you can't do it again. So it could be
okay?
example. I gave an example of a law. If they enact a law prohibiting subject that dealing with that subject matter of contract, you can't do it. You can't go on. It's not you are not the one that enacted the law. It's not your fault, but you can't go on. That's those are examples of frustration.
Yes,
Events,
my
frustrating
yes,
event.
my
Yeah.
lord. You gave an instance. You said you give an instance to show what frustration is not. So you said someone gave you a shop, leased a shop to you, but the person knew
Yes.
beforehand that that shop is going to be demolished or something
Yes.
like that.
Yes.
That's no frustration. So
Yes. Exactly.
what's the laws this and stand on such? What's going to happen in
It's a
such
breach.
instance?
That's a breach now. That is in fact it's even fraud. That is fraud. That is even fraud. It's even fraud.
So
It's one
Fraudulent act. Fraudulent
it's
act.
exactly
how will
it's
how will the
it's
person be
more
compensated? Like I want to understand the party now that has already involved his resources into that the person's resources are involved already, like the person that got the shop already.
yes.
How will that person be compensated?
Remedies. That takes us to remedies. So
Okay.
compensation. That's why remedies comes in. Why are you going to compensate it? Remedies will come in. You know. So someone has misrepresented to you that look because the issue of misrepresentation had that there are three types of misrepresentation. One is fraudulent misrepresentation. That is that something a fact is not true, but you represent it to the other party as if it's true. So deceit, you have deceived that person so they can obtain benefit of their contract. It could be negligent when you are careless because you know that you are giving that you don't even care to didn't bother about knowing from the government whether government is doing this or you didn't bother. You just say I want to listen. Or sometimes you are innocent. You are just someone that you are innocent. You say something believing it's true, but it's not true. So, but these are all misrepresentation, and so the consequences are also different. So the issue here is that when parties' rights are violated in a contract like this, what do? You go to court and seek compensation. So the compensation or remedies, there are different types. One is the common law remedy, which is damages, or the other one is equitable remedy. Equitable remedy is all about there are fairness, injunction. For instance, now like anticipatory breach, that someone is going to travel, and the person who will travel will affect your contract. You can bring an action to stopping that person from traveling by way of injunction, or you can you can sue the person for action for money held and received. So someone has collected your money to perform an obligation, but an event has occurred, unexpected event has occurred. Maybe the building has collapsed. Maybe it could be earthquake. You are supposed to use that building but that earthquake is not, but the building has collapsed, but you already pay money for that building. What happened? You can claim it for action for money hard and received. They'll give you your money back, right? It could be specific performance. Someone has failed to, it has breached the contract, but then it's such that if they give you the money back, if they refund the money back, you cannot be able to do that to build that place again. So instead of saying you take the money as compensation, you insist that the person must still build that place. You insist that the person must still build the place. That's what they call specific performance. Because damages will not come, damages will not be enough for you. If you want to be compensated by way of damages or pay you monetary damages, it don't be enough. So you insist that, okay, I'm not going to take your money, we must make the supply. I didn't ask you to give money, must make the supply, or restriction as the case may be. So, someone has, you supply your flour for bread to you, and you not use it. You go and carry your flour. But if you have converted that flour into bread, you cannot restitute it back. You can't take it back, in the position that it were before. Now, but so damages is compensation, is what you pay to the party for breach of contract. So it may be specified in the contract that look, if you breach this contract, this is what you're going to pay me. Like those are working in the contract of employment. For one of the common flags said that look, oh, if you want to terminate the employment, you must give 1 month leave of notice. That if you don't do that, give 1 month leave of notice, then they will, you will be you will have to you will pay 1 month salary. So that means that in that case the damages is being specific. Now, but then there are sometimes that you claim general damages. They are not specific, but there are sometimes that okay, someone is owing you money. In terms of trying to recover that money, you got a lawyer, you hire a taxi, you buy data, you pay a tracker. These are not specific, but then because these are money that you spend as a result of trying to recover the main money, that the specific money that the person owing you. So you can claim those ones as general damages. Now, but the rule is that what will cause the loss must not be remote, must not be far from the cost of that loss which you are claiming damages, must not be far apart. It must be closely linked to it. It must flow from the contract. It must reasonably connected to, contract. It must be fairly linked to the contract. Otherwise, damages will not be possible. And this was demonstrated in the case of Hadley and Bazendale. Can someone read that case?
Yes, sir. Before that, I have questions, sir.
Just can someone read this case?
Whether the
Hadley
plaintiff,
versus
Hadley and
Basindale.
Bazendale.
Hadley versus Basindale,
What?
1854.
Yes. What happened in the case? The first of the case. What happened in the case? It's online. It's a popular case, very popular case online. When you are discussing damages, you must know this case. And it's about remoteness of damages and all of those things. Yes, yes. What happened in the case?
Whether the plaintiff could claim damages for the
No,
loss.
no, 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 no. Go online, go to your phone and Google this case. That's what I meant.
Hello, sir.
Yes, go ahead.
All right, sir. So what I can see here is saying Hadley versus Basindale is a landmark English contract law case that established a rule for determining the extent of damages recoverable for breach of contracts. The case held that the breaching party is liable for damages that arise naturally from the breach or were reasonably foreseeable by both parties at the time of contract formation. Then went further to state that, okay, yes, that's all.
No, so but what happened? What happened? What was the dispute? What was the dispute?
The dispute is about
Retype it again. Exactly.
the background, talking about Hadley, a mill owner, contracted Basindale, a carrier, to
Exactly.
transport a broken
Exactly.
crankshaft to the manufacturer for repairs.
Yes.
Basindale was to deliver it quickly, but due to Basindale's negligence, the delivery was delayed, causing Hadley's mill to be shut down for an extended period of time. Hadley
Yes.
sued Basindale for lost profits during the mill's shutdown. That's the
Yes.
background, sir.
Yes. So you see that. So the court, see the issue is that he now sue that look, transport this to go for repairs. You delay it. Now they are now suing the transporter for profits that they would have made if they have taken that on time. So the court was determining whether the delay and the profit making, are they closely linked? Are there some things that you ought to have done that you didn't do, even on the side of the president, for instance? Are there some things that you ought to have done that you didn't do? So that's why it's a very popular case that I expect to go and. So what that case is also telling you that look, when there's a breach of contract, you don't just fold your arms and say, "Oh, let me fold an arm." If there's a way that you can mitigate the loss, you have to mitigate the loss. So, like that delay that was caused by the transporter, for instance, if there was option of buying a new one or hiring a new one to mitigate the loss that would occur, that's what they do. But they didn't do it. They didn't do it. They were folding their arms and waiting. So that was where the court did not accept such. So even when the contract, so if like for instance, even if you insure your house, if you have a contract of insurance over your house or over your shop, and the shop start fire, what do? You pack those goods. You are packing those goods away until when that fire is too much for you, you leave. That time it becomes unreasonable. But if the fire start, you throw the things away so that you minimize the cost of loss. That's how it's done. You insure your car, yet you still have fire extinguisher. If the car caught fire in unexpected, you use the fire extinguisher to quench the fire, even though the car is insured. So these things is not natural that local. You parties must take steps to mitigate the loss, because damages are only meant to compensate, not to punish the other party. Not to punish the other party. So must take steps to do what? To mitigate the loss. Yeah. So someone had a question. So please take note of that case. So I'm ever asked you in an exam or a test to explain the facts and the rule in the case of Harley and Harley and Bazender. Yes. So someone was asking a question. Yes.
Yes, sir. You have actually answered the question from the last explanation, sir.
Okay. Thank you. So now, what we have said so far in respect of monetary damages, that's they will compensate you loss. What the loss you incur has to do with things that are tangible that you can attach monetary value to it. But there are some losses that are not monetary, that injury to your feeling, mental distress, annoyance. Someone annoyed you because of the breach of contract. You are annoyed. That aside from losing the money, you're also annoyed. You have some mental distress. So you also lose your reputation, hard-earned reputation, bad feelings. Now, can you sue for all of those ones? This is another area. Imagine how many times contractors, people that you are entering into a contract with, have annoyed you. Even your workers, your employers annoy you at the place of work. You are angry. You are so bittered. Mental distress. Can you sue the employer for that, for breach of contracts based on mental distress or loss of reputation or annoyance? So the old law, under the old law, those actions were not actionable. We can't sue someone under the contract based on mental distress and some of those ones that I mentioned there. That was the old law. But now, it's the law. It's a remedy. You can sue someone if a breach of contract, someone has breached your contract. You enter into a contract that for supply of goods, they rely on you that you once you are enter you that you can deliver, you can deliver. Now you have hired someone under the contract to deliver those goods for you. The person failed you, your reputation is lost. So you can sue that person for not just the loss of the goods, the money that the contract that you would have gotten, and then also for the reputation that you lost in that regard. If you had medical reports show that you went through mental distress, because mental distress, feelings, and all of those ones, you must show medical reports. Cancer. So you have what they call non-pecuniary losses. Pecuniary losses has to do with money, but this one is non-pecuniary losses, mental distress, all of those ones. So you can always sue parties under for breach of contract that led to some of those things. Yeah, you know. So, ladies and gentlemen, that's where we are. And that also brings to an end our discussion on law of contracts. The door is open for questions.
Good evening, sir.
Very well.
This is
Teresa
Lawyer
Ote.
Teresa.
Yes,
Yes,
or
sir.
cancer. Senior cancer.
Yes, sir. Please, I have a question. What is law of thoughts? I just saw that in the document.
Yeah. A thought is that wrong, a civil wrong that is on a person. There's what they call a crime is an offense against society, but then a thought is an offense against a person. That person will have a discretion to either take action to sue or not to sue. So that's a thought, as it's just open like a crime is an offense against the state or the public. A thought is a private offense, someone that enjoy you privately. Like, but though there are some action that we constitute both a tortious action and a criminal, I mean, a public, an offense against the private person and cost against the individual, like slapping someone, slander, assault, and battery. It's a crime, and at the same time, it's an offense against, so all the offenses is usually have to do with reputation. If someone tarnishes your reputation, you have a discretion. You can say, you know what, you are Saint Teresa. So you know what, I leave you to God. God will judge you. But at the same time, you can sue that person claiming 20 billion or 20 million for your reputation. So that is just all about thoughts. It's a personal action and a wrong done against a person. Of course, the person will have a discretion to either, and unlike, there are some obligations. Obligations. The law itself will create obligations, that are of benefit to another person. Contract also create obligations, but contract obligations are created voluntarily. That is, parties will come together and agree based on the terms of that contract. Those are obligations. But then the law also imposes obligation on people that you must not do this one against this person. Those are where issue of tortious or tort comes in. What the law is, because these are law is a law that created those obligations. Look, don't slander that person, don't slander that person, don't defame that person. It's law that says so. It's not agreement between you and I that I will not slander you, you will not slander me. Right.
Thank you, sir.
Saint Teresa. So decide this are tortious action. If someone annoyed you, fine, you can say, I'm Saint Teresa. You know what? I leave it to God. God will judge you. So that you can go heaven too. There are cases whereby people have reported or did not report issues because when they ask, they say, no, I want to make heaven. Because God said I should love my enemy. Okay.
Okay, sir. This is noted. Thank you.
Okay. Yes, question time. Well, if you don't have question, I know you are in your house is enjoying yourself, taking your dinner now. Me, I'm still in the office, so let me also try and shut down. If you don't have question, this is the end of our discussion on law of contracts. We can always take it up from here in the subsequent classes. So I guess there's no question. So thank you guys, thank you ladies and gentlemen. Good time. Yeah, I have my time, with my learned colleagues. We'll meet again next time. If I'm the one coming around, if I'm not the one, any of our colleagues will come around. I'll just enjoy ourselves. I like being with lawyers. Just be discussing law. Right. All right, then. See you next week.
Thank you, sir.
Yeah, thank you.
Thank you, sir.
Thank
Bye.
you. Thank you, sir.
Thank
Bye,
you.
sir.
Thank you, sir.
Yeah, bye-bye, yes.
Hello, sir.
Oh, Sas.
Yes, sir. Sir, we appreciate if you share us the
Slide,
slide.
Abi.
Yes,
I'll
sir.
give you the slide. We're using it for that lecture, other strand. So once
Okay, sir.
done with them, so that everybody will have everything. I don't want to give you so that you can start sharing with those that
Okay, sir. Okay, I
you are ahead
understand.
of others. Others are behind. You are ahead of others.
All right, sir. Thank you, sir.
All right, welcome.